Okay, so recording has commenced. So a lot of people have said that this is a very interesting topic. My say, what do we need to do to secure our legacy? This virtual talk, which will be led by Mr. Pradip Saha and Mr. Pradeep Mansukhani, uh, who will take us into, make us do a dip and take us deep into the topic, supported by Mr. K.V. Vaidyanathan. So I can brace yourselves for a very interesting talk. I'm sure there would be a lot of questions as we go along. Please hold on to them. We will take breaks and ask you for the questions, or else at the end of the session, we will share email IDs where you can write directly and seek answers to those questions. So with that, and without much ado, over to you, Mr. Pradip Saha, to start the uh, overview and the preamble, and then Pradip Mansukhani will take over with the more detailed slide on the various legal aspects. Over to you, Mr. Pradip Saha. Mr. Saha. Mr. Saha. Somebody confirm if Mr. Saha is on the amongst the, and there is a lot of background sound with
some static, I guess.
Is that static?
I think it's some static. Okay, now it's better.
It's better now. Mr. He was there to start.
Yeah, he had joined actually.
Hello.
Yes, I can see him. He's on, Pradip Saha.
Can you hear me?
Yeah, Pradeep, we can hear you now. Please be a bit louder.
Why? Can you hear me?
No, cannot.
No, we cannot now.
Okay. Hello.
Hello.
Again, no?
Yeah.
Mr. Saha, can you?
Yes.
No, your voice is very low. Can we move on to Mr. Mansukhani's slides then, because your sound doesn't seem to be working well. Mr. Mansukhani, your slides.
Okay, fine. Okay. Good morning, friends. This is Pradip Mansukhani, and today we are going to talk basically on wills and nominations under the succession laws. The succession laws in India, basically, when you talk about this, hello, hello, can you hear?
I can hear you, Pradeep.
Okay,
Yeah, we can. You're clear.
okay. The succession laws basically are divided into two. There is an intestate succession and there is a
ये
testamentary
चालू है उधर।
succession. Basically, we don't have to go into the details.
हम्म?
And intestate
सुन रहा है?
succession is no, this is outside the slide. I'm just giving 2 minutes
अंदर से
background.
बंद नहीं हो रहा। किसमें था?
Hello. Somebody has the
किसका
speaker
अंदर था?
on. Can you please mute yourself?
ओ
I don't know.
मैडम
There's somebody's voice
किसका आईडी
coming.
में था वो?
Now, I'll start.
Go ahead, Pradeep. We're waiting.
Hello.
Yeah, go ahead. Thank you.
सॉरी
Go ahead,
Yeah,
Pradeep. Thank you.
okay.
प्रदीप सर।
Okay. So succession laws in India basically is intestate succession and testamentary succession. And intestate succession is a succession where a person dies without a will, where there is no document. So in that case, that person is governed by the inheritance laws applicable to him in India. Now, for example, we are not going into a lot of details. I will just tell you that there are different category of people to whom different laws apply. Now, there is a Hindu Succession Act of 1956, which applies to Hindus, Sikhs, Buddhists, and Jains. Then there is an Indian Succession Act, which applies to Christians, Parsis, and Jews. And then there is a Sharia law, which is applicable to Muslims. So these are the three types of categories where the respective.
प्रदीप के स्पेलिंग P
Sorry, hello.
R D
Where
Let's
these laws
just mute
apply.
ourselves,
Okay.
please.
नहीं प्रदीप का आईडी में तो नहीं है। प्रदीप का आईडी में नहीं है।
I think the admin can mute
Yeah.
everyone.
Admin, Ghosh, why don't you
Yeah.
just mute everybody, please?
Yes, except Pradip Mansukhani.
Yeah, thank you. Just mute everybody.
Okay, next.
Sorry, Pradeep, go ahead.
Next, yeah. Yes. Yeah. Now we come to the wills. Now, will is a legal declaration by a person to bequeath his or her assets and properties after his demise. So, what happens? A person has to make a will and name the beneficiaries in that will, and he has to mention all the assets, which takes place after the person's demise. So, it will not take place during a person's lifetime. That is a will. We'll go further. Next, please. If you don't have a will, then the assets may not be distributed as per the wishes of the person who makes a will. Because sometimes, we would like our certain assets like immovable property to go to some specific people. Now, if there is no will, then, the person's wishes are not implemented. Then in that case, the legal heirs have to go through legal process, which is very expensive and time consuming.
नहीं सुन रहे?
Yeah.
सुन रहे?
Next, please.
तो ये लगाओ एयरफोन।
PS, just mute everybody, no? Please. Except Pradeep.
Yeah, next slide. Next, please.
Yes, what happened?
Just a minute, I was muting people, so I can't share and mute both at the same time, so I'll have to do that again.
Okay.
Okay. Okay. Pradeep Mansukhani, are we here? We'll
Yeah,
move
yeah,
forward.
I'm there. Yeah. Okay. Is it mandatory to register a will? Now, what happens generally, it is not mandatory to register a will, but it is preferable that you register your will because when you go to the registrar and register the will, he notes down the details of the person who's made the will as well as the two witnesses who execute the will. So tomorrow, if a person dies or if the witnesses are not available, it leads to the genuineness or authenticity of the will. Yes, this will was executed by this person because all these details are noted in the registrar's register. So it is always better to register a will. Now, who is an executor? An executor is a person who usually a close relative or a trustworthy confidant named in a will who is also a major at the time of making the will. You have to name the executor that after my demise, all my these assets and properties will be executed. You appoint an executor who will manage and implement the decision of the demised person and execute the will. So he manages, he implements, and he distributes the deceased asset according to his wishes and instructions contained in the will. Now, this is very important that we have to keep in mind while making a will, which are the do's and don'ts while preparing a will. These are basically certain basic conditions for making a will. A person has to be a major above 18 years who can make a will. No stamp duty is payable on a will. A will can be just made on a plain paper. It can be handwritten or typing, and it has to contain certain details like the personal details of the testator. A testator is a person who makes the will. So a testator will make the will declaring that he is of sound mind and he is making the will on his own accord without any force or coercion. Then a will contains the list of all movable, immovable properties. Now, in certain cases, some people mention all the details of the properties, the details of their bank accounts, FDs, shares. They attach an annexure or a list. Otherwise, what they can do, they can also put generally that all my movable and immovable assets after my demise will go to so and so. So it all depends. Some people list out all the assets in the will. It all depends on you. And then the very important is that in the will he has to declare that upon execution of this will, any former wills they all stand revoked and cancelled, including a registered will. Because the point is you can change the will any number of times. So if he makes a new will, he has to make a declaration that all my previous or earlier wills stand cancelled. Then you have to name the beneficiary that after your death, all this property will go to whom. Now, beneficiaries may or may not be legal heir. It could be your anybody your friend also who will receive your assets upon your demise. And then it also contains the name of the executor along with the photo and address identification. The executor who will execute the will. And of course, the will has to be signed in the presence of two witnesses. They have to put their name and address. And nowadays, what is happening is, because this will is a legal document, it is better to attach your family doctor's certificate. A doctor generally, he will certify that this person is executing the will, he is of sound mind, and he is of good health. So it is better to attach the doctor's certificate with his stamp and signature so that it lends authenticity to the will. The the will does not automatically transfer the property to the beneficiaries. For that, you have to go to the court and obtain a probate of will. We have to make an application, and this probate is issued by the High Court. And only after that, the property gets transferred to the beneficiaries. That is how the will be converted into a title document. Once each court issues the probate, it becomes a title document to deal with the assets and properties of the deceased. Yes, a will can be modified any number of times. A codicil is basically when a testator likes to make some minor changes in the executed will. For example, he wants to change the details of assets mentioned in the will, or he wants to change the executor or the beneficiary, then what happens by way of a supplemental deed, which is known as a codicil, it is also a legal document. So he writes all those changes in the codicil and it is attached to the will and it forms a part of the will. The original executed will stands unchanged because he cannot once made he cannot change make any minor changes in the will. So codicil is a supplemental will, you can say, which is where the details of the changes are mentioned and it attached to the will. So it becomes the complete document. For a probate, you have to make an application to the High Court. A probate is also a legal document which determines the genuinity or validity of the will. In case there is some kind of a dispute or somebody doubts that this will is a fraud, then you have to obtain a probate from the court, and that is the conclusive evidence that this will is genuine. And of course, it becomes title of property. It can allow you to deal with the property. Now, what happens when
Yeah, Pradeep.
it's not coming here for those
Oh,
notes.
my screen is not visible.
Only the heading is visible.
So that is because it's you start talking, I will move on.
Okay.
Just a minute again.
So when a person doesn't execute a will and when there is no will, then you have to obtain some sort of a legal document from the court to prove your legal heirship. Especially in case of cooperative housing societies where we all have flats, uh, if there are nominees, then the nominees do not automatically become absolute owner of the property. They only act as a trustee or caretaker, holding the property for the benefit of legal heirs. Because generally in a cooperative society, first of all, if there's a demise, they will ask you for a will. Now, if there is no will, then the nominees have to obtain some a legal document because the nomination does not confer ownership rights on the nominees. Ownership rights are governed by the succession laws. So until their ownership is established through legal document, they have to obtain a succession certificate or a letter of administration. Then a nominee can be registered as a provisional member only. His name cannot be registered on the share certificate or the register of members in the society. Okay, now just by the way, just as a side topic, I just chose to mention this because this also nowadays is very important and it is becoming very common, especially in case of properties. You know what happens if you want to give some property or assets during your lifetime to somebody ABC, so that there is no any kind of dispute or any type of confusion after your death, then it all goes haywire. So in order to make sure, what you can do, you can execute a gift deed while you're alive. Now this is not a succession document. A gift deed is a legal document whereby you execute currently, naming the people, then you have to give a gift of your property to those people. So gift deed is a legal document for a voluntary transfer of ownership of property. The one who gives the gift is the donor, one who receives is the donee, and it is done without any consideration out of genuine love and affection. So basically, if we see main features of the gift, because nowadays this is very important and a lot of people are executing gift deeds, especially for their properties and flats. So first of all, it is a legal document. It covers both movable, immobile properties. It is done voluntary without any consideration because it is out of love and affection for somebody. You are close to somebody or somebody is your favorite. It may be a family member, a legal heir, or anyone. You can execute a gift deed and give that gift to him. Now, the person who's executing the gift deed, the donor, has to be a major, 18 years, and he must be owner of the property gifted. You cannot gift a property which you don't own. And the donee must accept the gift one to whom you are giving the gift. So both the parties have to sign the gift deed. Another thing is it comes into operation immediately on execution. It doesn't come into effect into future. It is immediate. Upon immediate, it comes into operation immediately on execution, and it transfers interest in the property at present. Now, in case of a gift deed, unlike the will, there is no stamp duty. Here, you have to pay the stamp duty on the will, which is different in different states, as per the state laws. Now, registration of gift deed is also necessary to be witnessed by two people. Now, most important is that generally a gift deed once executed cannot be revoked or cancelled because you have made it absolute. You have given your own property to somebody absolutely and forever. So you cannot take it back. It cannot revert back to you. It is gone out of your hands. But there are one or two exceptions, in which case this uh, gift deed can be revoked or cancelled. Suppose tomorrow, if it is proven that it is gift deed is executed fraudulently or under coercion, then in that case, a gift deed can be revoked or cancelled. And another most important thing which is happening nowadays is, in case of senior citizens. Now, for example, you may be knowing the case of Raymonds of Mr. Vijaypat Singhania and Gautam Singhania. What happens? A person executes a gift deed and he puts in the gift deed, a father giving to the son that, I am gifting this my big palatial house to you. You will take it absolutely forever. But what happens? A condition in that you will take care of me until the end. You will take good care of me and help me and look after me. So that is a conditional gift. Now, if that condition is broken, suppose tomorrow they start abusing and harassing the father and drives him out of the house. Nowadays, so many cases are happening. Then he can go to the authorities, the court, and prove that this his son has misbehaved with him and done all this. In that case, the court will cancel or revoke the gift deed because the condition is not met. They have failed to comply with the condition, and the court can also order the son or whatever his family to get out of the house because they have not complied with the condition upon which the gift deed was, upon which the gift was given to him. So that can happen in a few cases. A gift deed can be revoked. Now, why to execute a gift deed? Because nowadays a lot of people are executed. It allows immediate transfer and ownership of asset and properties during the lifetime of the owner. Now, this is very important. Instead of leaving it to the legal heirs to fight later on, when you are not there in the world, you cannot control. You don't know what is happening. So, within a lifetime, you give it to the person whom you like, whom you prefer, and so, as per your wishes, you can give. So, it prevents future disputes and claims, especially within the family. And then gift deed, of course, is more cost effective. There are some different rates of stamp duties are payable when the gift is between the family, say between a brother and sister or between the parents and children. There are different rates of stamp duty. It is cost effective as compared to when you go to the court for a probate of a will or a succession certificate, because there is a stamp duty and it takes very long, about 1 year, and other expenses are there. So this is cost effective. Now, living will is a very new concept which has come into effect.
So,
Uh,
Pradeep, you can take a sip of water
no, that,
while because we are changing topics now.
okay, okay,
Uh,
thank you, thank
and to everybody else, I'm sure this was a very, very important session, and you may have some questions. It would be nice of you to make note of those and keep them till the end when we will discuss those, or you can mail them across. I'll be sharing the email IDs of Pradip and Sukhani. You can write to him asking for those clarifications at a later time. Pradeep, back to you again. You can
you. Yeah,
move
yeah,
to the living will now.
yes, yes. Now, living will is a new concept which a lot of people are making nowadays. What happens is that sometimes the person, okay, it's a legal document where the person states about her future medical treatment in case they become seriously ill or unconscious and cannot make any decisions. Now, sometimes we, even in case of our own family or relatives, we find that some of our relatives and all, they are in the pitiable state. They are maybe in the hospital, they may be in coma, or they may be in ventilator. Now, at that stage, a person cannot, decide. He is not even conscious to talk and say what he wants and all. So A living will is made by a person saying that, tomorrow if they're seriously ill in the hospital and all, so in that case he gives his wishes in the living will about the treatment to be given to him by the doctor. Because nowadays, suppose a person is on the ventilator, so a living will he makes and says that, in case I come into that condition where, there's the use of ventilator or tubes or dialysis, then please don't go ahead with that. So it is a guide to the doctor also. So it's a legal document where a person states about his or her future medical treatment in case he becomes very seriously ill, unconscious, cannot make any decisions. So this will guide the doctors and family members whether to continue or stop the treatment, especially when there is no hope of recovery. Because sometimes you feel, in the hospital, they say you'll be on ventilator 1 week, 2 weeks with no improvement, no further hope. Then they say, you please start praying. Now there is no hope. We give up. So in that case, this living will helps because it indicates the wishes of that person that you know what to do. It helps to avoid confusion. So will and living will, we know the difference since we have discussed. A will outlines to whom the person's asset property will be distributed. Living will provide the instruction about basically about a person's medical care when he becomes incapacitated or unable to communicate their wishes. With the advanced medical treatment, life can be artificially prolonged, so it becomes difficult to judge whether treatment is helpful or it is delaying the death. So it prolongs the suffering, emotional distress, expenses. So in this case, we go by the person's wishes if he has made a living will. Now, who should make a living will? Nowadays, I mean, everybody generally is making, especially senior citizens. So, in case of any terminal illness, Alzheimer's, they are in coma, they can specify the kind of treatment they want. They can refuse the use of ventilator, dialysis, living tubes. It will state the name of the person who will carry out the instructions of the testator. It can be also updated and cancelled because that is the latest form of will. Now, who should have a copy of the living will? Obviously, the people who should be aware. So, original is with the testator who makes the will, and copies are given to family doctor and family members who are aware of his decision. Now, very important is that I think Maharashtra government are on 16th or 18th of August, just I think next week, they are creating a web portal on which the living wills can be uploaded and verified by the treating doctors. This is a very important, and I understand that in Hinduja Hospital Mahim, they have set up a separate division for living wills, where I think people can go discuss and sort of execute the document. Something is there with Hinduja Hospital Mahim. Maybe you can call and find out. Okay, now next we come to the succession law, which is of nominations, which is also equally important. Now, nomination is generally a method by which, legal process by which a person is nominated and he substitutes the original holder in case of his death. Now, this is very common in case of housing societies. Whenever we buy a flat or we come into a new society as a new member, we are asked to fill the nomination form where we mention the names of the nominees and the shares of the nominees. Suppose we write A and B and nomination share is 50-50 to each, whatever it is. But this is done by way of a nomination form where the nominees substitute the owner on his demise. Now, nomination is very essential because it is the designation of the beneficiary to receive specific assets as a nominee in the event of death of the nominator. But that nominee cannot deal with the assets since, as a nominee, he does not become owner of the property. He is only a caretaker or a trustee of the property. Now, advantage of nomination is that it ensures smooth and hassle-free transfer of assets to the desired people. Now, in case there is no nomination, the survivor will not be able to deal with the assets and properties of the deceased, and they will not be even able to let out the property on rent unless there is a legal heirship is determined. Nomination form is a testamentary document, just like a will, but it is restricted to each specific item of assets. Now, for example, we have got so many investments. A nomination form with the cooperative society is different. But when you go to the bank, your mutual funds, fixed deposit, insurance, each of the organizations have their own nomination forms which you have to fill and give. There are different nomination forms in case of different assets and securities. Like I said, immovable property, FDs, mutual fund. When you go to them on the counter, they will give you that. This, if you ask for they will in fact already get the nomination form from you. So on the death of the nominator, there are different set of rules applicable for the transfer of assets and securities in favor of nominees. Each of them is different. Now, nomination does not automatically transfer ownership of assets or property to the nominee. See, in case of property like flats and offices, a nominee holds property only as a caretaker or trustee. He does not become the owner until the legal heir is determined. This means that upon the demise of the nominator, the nominees have to, through legal process, obtain a legal document, a probate succession certificate, letter of administration from the court, in order to determine the legal heirship, in order to deal with the property. Just a nomination form, when the person dies, you become nominee, you have got no right to deal with the property, neither you become the owner of the property. Now, this is important. What happens that in the case of immovable property, suppose the society also, because as I said, the nominee does not automatically become the owner. The society will insist that you get some legal document from the court. Now, if there is a will of the person who has passed away, then they will tell you that you please get a probate from the High Court for this will. Otherwise, you get a succession certificate of a letter of administration to transfer the property to the legal heirs. So there is court intervention is required in such cases. Now, in case of other assets, generally what happens if you have got like demat shares, fixed deposits, PPP, PPF, mutual funds, bank lockers, insurance policies, they generally do not insist on a court document. They transfer the assets in favor of nominees, subject to submission of certain documents, but with certain respective financial limits. I will give you one example. Suppose, for example, you have got demat shares. Okay, so demat shares, what happens? Your DP will say that generally, what happens? All these organizations, they have their own forms. They have their nomination forms. You have to give the. I have mentioned here the document which generally they ask for is the original death certificate of the nominator, transmission form, which they have each organization a separate transmission form, KYC of the nominees, indemnity bond, affidavit. See, these are the simple documents where they will give you a set. You please execute this document and give it to us. Now, what happens in case your amount of investment large? For example, in case of demat shares, this is allowed up to 5 lakhs. In case your value of demat shares exceeds market value, exceeds 5 lakhs, then you have to obtain a succession certificate from the court, because it is as per the SEBI guidelines. You cannot, transfer the shares. Below 5 lakhs, you can transfer. So that is what happened in case of mutual funds and PPF, this bank accounts, FDs. They will give you a set of nominations, and they also have a limit, like that. In that case, they take some additional document, but there is no court intervention in case of these organizations like mutual fund, PPF. They don't tell you that you get a succession certificate or a letter of administration. That is the major difference. Nomination generally, all like in society also there is a register of nominations where all the details of nominations are entered, like the name of the nominator, name of the nominees, share of nomination, all that. And even other organizations, insurance companies, they have their own register of nominations, which is modified, updated from time to time.
Okay, so that brings us to
Okay.
the end of the slides. Thank you, Pradeep.
No, thank you.
Before I open the house to everybody in terms of asking questions, I would request Mr. Pradip Saha, who we couldn't hear initially, if he would like to add anything, and also join Pradip Mansukhani to answer some of the questions that may come up now.
Yes.
So, questions, please. You can unmute yourself and ask your questions.
Patto, can you hear me now?
Yeah, we can hear you now,
Yeah,
loud
can
and
you
clear.
put a
Please.
one slide which I want to tell as a broad guidelines? If you go to the first 3 pages, the people should know how
Okay.
to move. Just first, I'll tell you for 5 minutes because now we told. Go to the next one. Go to the next one. This one, previous one.
Huh.
Uh, as we are gone ahead with the details, how to make, what is the necessity, and how to move forward. But I thought that to share with the team that you need to know your financial status. In the will, you have to write specifically for mutual funds, for demats, for your assets, any assets paper. So that is need to be done in case of financial status. Then obviously you are doing over the time with your wealth management, which is changing time to time your status. That's why I need little bit updation, as Pradeep told that you have to review once in a year or something. So that can be updated. But he was very clearly told about medical insurance, which is a very necessity in the life, and the living will concept, which is there. And it's a good that every state is now putting in the hospital, like he has told in Hinduja, in
Yes.
like Calcutta, there is some Bellevue. So various place you can take the guidelines of the living will, which is the, and then obviously will and nomination you have detailed, you understood and detailed clarified. So I'll go to the next chart to tell something briefly, which is not the legal, that financial status, we know three aspects. One is the land, buildings, flats, whatever manufacturing units, if you have one. And then we obviously talk about movable properties as, but I would like to tell that one division, like insurance policy, you can give a beneficial owner, so then don't have to go to succession certificate or will. Even will you mentioned that is also overruled. So in case of insurance policy, you can give beneficial owner, like if you give it to your wife, and when you are no more there, it will go to succession, not required. Wife will get, irrespective of the will. In case of employees provident fund and gratuity, also you can make in the company registration. That means that employee will give it and there is no requirement of the will. And obviously independent homes, as Pradeep clearly told, you can give a independent give deed or transfer. So these little bit exceptions where you don't have to go to it. Artun, can you go to next chart? Here we thought that, as we are becoming a little bit older and government is giving through various process, I request everybody, I didn't make it still today, everybody should keep it one file, like we used to do in the office time. Your PAN card, Aadhaar card, nomination, title, deeds of property, municipal tax payment, housing cooperative society, credit card copy and restriction. Like recently, a lot of transactional fraud happened. The person has given a credit card, but did various expert people do the fraud, and it has been found out in the cases that restrictions are there. So I cannot make any transaction more than 50,000, but credit card fraud people have carried out transaction. It is allowed. So those type of things should be kept, like by life insurance policy, life continuity explained policy, bank accounts number, demats, car blue book, last 3 years tax returns. And a lot of people now keep it like in one stock, CSDL summary or NSDL summary. That helps as a way forward. Partho, you can go to the next one. So as we said, Pradeep was very clearly told, simple words, nominee acts only as a custodian. He cannot own, he cannot distribute, he cannot do anything, but he can hold. And if the nominee dies, then there is a process. You can work it out such a manner, then legally it is clear. One thing is this, nominee cannot own, hence the legal heirs are required to be determined.
Correct.
And that's why succession certificate, all these comes laws of will.
Yeah.
And the will facilitate that, as Pradip told very clearly, that you can write handwritten, typed, only two witnesses are required. That two witnesses are very, very important. When you have to take the probate, these witnesses may be summoned in the court before certifying the probate. The question comes, if the witness dies, what will happen? Because when you made the will, you made your friend, colleague to whom you trust, and then, witness is no longer there. So that is another process to be done. Property is transferred according to laws or will. Simply, whatever will you want your desired expectation money to move someone. So as per the will, it will move. And will can be easier form to take the succession certificate and probate. There is a one, he has advised that registered will, which is advantage. If the legal person who has the having the witness, and if the witnesses are not there, then registration of will helps, because wills witness people have been called in the to make a probate. But if your wills are registered, then the government certification is there, and that makes a very valid and easier form to do probate. So indirectly, nominations means only you transfer to legal heirs. That is a job. Role is to manage property until you transfer to legal heirs, and division applicable when, like I told you, life insurance and employee provident fund and gratuity, where you submit the company the form, company will give it. They don't go to the legal heirs. But if we can go to the next chart. As Pradip has very clearly told that will is a legal document. Property will be distributed as per will. So that will makes you comfort to whom what you want to share your hard-earned own property. You cannot decide your ancestral property in the will. So your own property only you can do. And if one lot of people tell will is not there, what will happen? Will is not there. Indian Succession Act will be applicable, and accordingly people will get the share. So will should be made 18 years, that we told, sound mind, handwritten type. But one thing is this, will should mention details of assets specifically. Nowhere book it is written liability. Liability also should be mentioned, so that if you have any liability, the executor should pay the liability and make the net assets to distribute.
Yeah.
And you have one question has come, like, if executor die or executor is also same age, executor should be also of sound mind. So executor should be measured. So there is a process that you can take to the court, and they can appoint any of your relatives or any of the person with competent mind to be executors. Only thing is this date and place should be very specifically cited in the presence of two major witness, because that is very important for your applicability. As he has told, notary and registry is optional, and registry will prefer the advantage of third-party verification like government. In simple, nominations only for custodian of the property. So your property will go to the desired person as per legal heirs. Will helps your will, your wish to support to whom you want to give the property. Next one, if it is there. Hello, Partha? Yes, Pradip
That was your last slide.
Pradip has gone through the very details. So I request team, please put your assets in the list summary. And as we know, whatever Excel form or printed form, Word file, and decide the asset distribution. That will help
Right.
as a future your wishes to be fulfilled. Thanks.
Partha, can we ask a question to Pradeep now or later?
No problem.
Now,
Okay. Okay, so the question, firstly, Pradeep, thank you for all it's a very simple presentation, and thanks to CPIA team for putting this up. Two questions, Pradeep. What happens to assets overseas? For example, if I have assets in terms of tangible assets in the US, in Canada, in London, those assets, what happens to mutual funds which you have invested there in dollars or in pounds? I understand that the Indian will does not cover those assets. Is that right?
Yes, Indian will does not cover that assets, but the will, if you made as a in India, that will needs to be certification, and
Yeah.
that will go to the through embassy to the government,
Right.
and they will certify that. So basically, if you are citizen of India, you are paying tax in India, then you can make the will applicability. Otherwise, if you are not, if you are citizens of like Canada or USA, that will of that law will be acceptable according to that state, and that will be acceptable in India. Suppose you have given to your brother who stays in India, but your property is in America, so that will be certified in the USA. Even the will is made here based on the court succession certificate approval.
So Pradeep, I'm a PIO, person of Indian origin. Okay, so I do have assets overseas.
Yes.
What's the rule for that?
They like suppose today I am telling you to like we get in Colgate sometimes ESOP shares.
Yes,
The shares are specified there. And if you see the shares you got, there is a no nominee process itself, made in launch
correct,
and something.
correct,
So what actually happened, you made the will for your property, which you own.
correct.
If you want the property, that will be certified by the Indian court as a probate, and then you have to submit to the USA to get that property certified, plus applicable tax as applicable.
So what I was told, thanks Pradeep, what I was told was that you could actually have a separate document, a separate will for those assets, which
Yeah.
has governing law between US and Canada. I just have one common will, is what I was told we could do. Is that
No.
a fair point?
I will tell this will give a disadvantage in the sense that you are making a will, you are sending only the property you held in USA.
Yes.
You are not giving the question of doubt in India. So if you make it two separate will for the property staying in outside India, you see nowadays problem
അല്ലല്ല
is that in
പ്രദീപ്
income
പ്രദീപ്
tax law,
സഹായാണ്
yeah, sorry.
അല്ല ഇടയ്ക്കിടയ്ക്ക് വെക്കുകയാണെങ്കിൽ കണക്ഷൻ പോയി എന്നുള്ള ഒരു
Yeah, I want to tell the taxation law nowadays you have to declare the assets staying in abroad. So
Okay.
that is the vetted documents by verify by the government. So if you make it separate, then only for that portion will be applicable. Otherwise, you have to give the total file, total will, total assets, total combined. That will make little bit inconvenient. But so long you are do truthful everything, then nothing is inconvenient. So question is coming like why they are complicated. Suppose in case of Muslim law, there is something different. Will cannot allow you to make more than one third to your family. So yes, and all these people look into various cross perspective. Here you can get a certified by the court. You have to submit that, and that will facilitate you to take the asset to the desired person you desire.
Thanks, Mr. Saha. Thank you very much.
Thank you. Pradeep, there is, can I ask one question regarding the classification of the assets to be made it seen on the will? Only the classes you need to like mutual funds, FDs, that has to be mentioned, or the actual value has to be mentioned along with?
Yes, if you can, like nowadays we get a CSDL report or NSDL report. If we attach the details of the report, which is 45 pages or 10 pages,
Right.
so that gives you a little bit confusion because as
Yeah.
on that date you get, correct? And you are changing. You are making will today. Today, based on the property owned by you, can make a will. Suppose I cannot make will my parents' property. So that is parents' property will be owned by their his successor or legal heirs. I can will my own property. So as a result, either you can attach your property, which is the CSDL reports, shares, mutual funds, a lot of things come, and you can take extract from them and write as per annexure. But it is very advantage or specific assets should be given because you can give it to various people. Suppose I have only my hair is wife, so I can write to one person as your correct leader.
Yeah.
But suppose I have a son, daughters, I don't like son or I don't like son's wife, whatever may happen. So at the end of the day, you are a correct person to decide to whom you wish to give. Like you recently see that, we say the Ratan Tata has given 1,500 crores to the one is the executive secretary. Would have been, know where he gets, but a will is there, registered, so what is given. So it helps you if you make a specific as on that. supported document, but it can be changed. So you have given a mutual fund value as 55 lakhs. Now USA government has come, you'll be doing 45 lakhs. And if tomorrow something happens, you'll get 60 lakhs. So value you cannot determine. Mutual
Yeah.
fund also now. So it will become a confusion. So better you put it as on date attached reports, which you do.
Okay. Thank you, Pradeep. Pradeep, the executor can also be a beneficiary of in the will. Is that
Yes.
possible?
Yes.
Yes.
Okay. Okay.
Sishir has a question.
Pradeep, Pradeep Mansukhani,
Yes.
because both are Pradeep, this is Prabhu.
Yes. You can call me PM.
I am talking to Pradeep Mansukhani. I understand that probate is applicable only in metropolitan city like Mumbai, not outside Mumbai city limits. And Chennai or Delhi, High Court, because high courts are based in cities, and even society where I stay in Thane. Probate, as I understand legally, is applicable only in the metro city limits of Mumbai, not even in Thane. Is it right?
No, but then the courts have got jurisdiction. No, suppose you're staying in Thane. If there's a court matter, then I think it's the Bombay High Court you have to go to, because they have the jurisdiction of various areas. So it is not that you will not be required to take a probate. You will have to take a probate, go to the court of proper jurisdiction, and get the probate.
Because probate, we went to lawyer in our society. There was a case. They said probate is not mandatory if the will is very clear.
If the will
probate is only applicable because probate has a cost. Then every will, if you go to high court, probate cost itself is around 1,50,000.
Right.
Lawyer fees and court fees itself is like 80,000-90,000 or a lakh of rupees.
But then, if
so probate, as I understand legally, also senior lawyer, they said is only applicable in Mumbai city limits. Not even in Thane, Dombivli, Kalyan, or say Vasai.
I don't think that is correct, because a probate, basis on the will, first of all, all well-governed societies, they will not transfer on the basis of a will. They will definitely ask you, will hai to aap probate leke aaiye, because on the basis of will, they cannot transfer. They are only nominees, and the title will not be perfect. So I don't think if they are telling you like that, that's my opinion. I don't, maybe.
Prabhu, one thing I tell you that in Calcutta, any property, Bombay have not done it, Pradip Mansukhani can tell more, or even Mr. Vaidyanathan here, he can touch on it. But in case of Calcutta, you have to go through the court to make the probate, because will is your internal desire. You
Will
have put it.
without probate is not
certification is required
implementable.
Because you cannot register your name
in
the property.
Yeah, but that is what I said. It is only for Calcutta also is a metro city.
Yeah.
So only for specific big cities it is mentioned probate. Not across villages, towns. Everyone will not go for will to high courts. That is what I was saying.
That we can take to clarity. Even
please recheck this, because
Mansukhani can give a response also.
Because every town, village, 80,000, 90,000 going to high courts is simply not physically possible for any courts also. If wills are there across India.
It's a good question which can be fact checked and we can revert.
And I'm telling specific case because it happened. So when it was said probate will is required, probate is required on every will. Imagine what it will be in high courts across India.
Yeah,
why I'm telling you,
question. We will.
I'll tell you one thing, that suppose today you are a member of a society, you give the nominee cannot become owner, because nominee is a custodian. Even he cannot give rent. You cannot go registered office.
Nominee with clear will.
Contradictory. So
nominee with clear will, of course, which says that this is my, this is whom I am bequeathing my property as per will. And then nominee is on the register, I and J register of society,
Yeah. Nominee is in the register as per requirement, but that nominee concept of cooperative has come even 20 years before. But
and will says that yes, after me this is also, so will with nomination is what
Okay. Anyway, I understand
the necessity of a probate can be checked, particularly for non-metro cities and stuff.
And for villages like.
Yeah, we can get back to everybody on that. Shishir,
for everyone.
I have a question.
Shishir,
I have a question. Is it Ravi?
No, Shishir has a raised hand for some time. Ravi, can you just pause for a minute? Shishir, can
Sure.
Yeah, thanks, PS. My question, I mean, I've lost touch with the laws in India. I live in USA and the laws are different. But I'm just trying to understand the Indian perspective because I might have some interest there in the near future. My question is, what happens if there are assets discovered after death? For example, somebody buys a bunch of cryptocurrencies and forgets about it to include in the will. Would that, if it's a good value later on, say 20 years down the line, if the will is put into action, is there a provision in the will to distribute such assets?
If the question is coming in the take, is this asset specified in the will? No.
No.
Correct, if I assume correctly. And if the assets have come to you, maybe after 20 years, 10 years, or 5 years, if it is not mentioned in the will, it will go as per succession law. Will is not compulsory. Will is your desirability. As per succession law, your appropriate legal heirs will get the property. Or when you become owner of the property, you can give another will to applicable. So will can be changed, modified every day. Last will be valid. Even the will is registered. It next handwritten will with the date, proper witness invalidated the earlier registered wills. So question is this coming, your property, your desire, you can decide. Even the property you don't know today exists, tomorrow it is accrued. This will go to your legal heirs, even you don't make will. So as per succession law, will is not compulsory. Will is just a option.
Yeah.
The people have a property, they make the will. Poor people does not make the will. They have a money 10,000 or something. That's why will is not that. You'll go to your legal successor. You get your certified by legal successor, like village I saw, a local MLA or something certified. They get it, that type of small bank accounts, something like. So it is will is not compulsory at all. So will is your option. Your succession is the compulsory as per Indian law, so that automatically will go to your legal heirs, which is established. Like suppose today I am there, my mother is alive, my wife, son, daughter. So it will go to wife, son, daughter, and mother also. So it is, and will you can decide my mother will go. So that is the way.
Okay, Ravi, your
Thank
question.
you so much. Okay, thanks for explaining.
Yeah. Yeah, my question was thanks, Pradip Mansukhani. My question is it beneficial to take a legal succession certificate in advance in
No, you
the
cannot take.
first?
You cannot take. You
No.
cannot take succession certificate only when you are not there. And that will be taken by your legal heirs, not by you. You can give a will, and that is a called succession certificate indirectly. You can decide that I'll give property, everything to my wife. So you can give 100%, or I give everything to someone. You can will does not mean that you give to a relative. That's why I told you
So which
local
means my
government.
son. So Pradeep, for example, if my son can take a succession certificate when I'm alive, or is it
No,
No,
possible?
no, no.
That's my question.
no. It is only applicable
Okay.
only on the demise of.
Of the device.
Understood.
Yes, yes.
Understood. Thank you. Thank you. Thanks.
Any more questions? Ravi?
Yeah, I have a question.
Uh,
Does every will need a probate?
Will is the basically your paper, your requirements. You might have made the last will, but that will is not available due to some reasons. It has been suppressed. So will needs a probate means what? Suppose today you made a will, you have a property, but you have a liability also to government of India for income tax or municipality authorities. So the court is the job is to communicate to the all restricted people, including publication, so that they can give a free certificate to you. Once you get a certificate, then you can sell, you can decide. So will of probate means is a third party, which is like a court in India, who does all verification and validation. That makes the other person doesn't have any problem. Suppose I buy a property from you, you cannot sell the property. If the will is there, then you are automatically owner. So I am not also problem. I may not get the. So that will is basically certifying documents by the government to make a probate. Otherwise, will has no significant value. So you might have given a will today, and after 2 months you made another will, but you suppressed. Then somebody come in the court. This will is come in my name, how this will can be valid. So that's why the probate means third party verification, which is the government.
Yeah. Right.
I think Srini has got some question. Srini?
Srini has a plot of questions. Right?
Oh, he had some.
Do you have a question?
I thought he put it
Hello,
down there.
Hello, everyone. This is Lata here.
Hi,
Yeah. Okay.
Hi. So I just wanted to check with you, Pradeep. If you have two properties in two different cities, do you have to have probate from two different high courts?
No.
No.
One high court.
Where you're residing.
Where you are residing, where your PAN card, Aadhaar card, whatever documentation is available, you submit to the court, that court send it to the verification process. It's a India, the court you give directive, that court will do it.
Oh, great. Thank you.
Pradeep, I have one more question. What happens if the executor, dies before the person who makes a will?
Yeah,
you will have to make it again?
No. You have to submit that the executor is not there. During your lifetime, you obviously can change the executor by making a new will. Will can be made is like a new will. So that is the one option you have. Another option, if it is executor is become unsound, after 20 years you made you made to me as an executor, and after 20 years I may not talk also, I may not talk. And so then the incapability will not enable him to do execution. So court will appoint executor, or there is a one word which Pradip Mansukhani can tell, right of administration. So that type of approach is there.
Okay.
I have a question, Pradeep. Hello?
Yeah.
I have a question, Pradeep. I have a will which was made somewhere 6 to 7 years back. Now I want to register the will now after 7 years. What is the procedure? Can I do that?
Yeah, obviously you can do it. You can do it when you make a will and go to register. No, you go to the sub-register, same will, you submit, you get a registration. That's it.
Okay, and for that registration, do I need to take the witness there?
Yes.
Both the witness, whatever.
Both the witness should be available there
at the time of registration.
And doctor certificate.
Yeah, basically, if it is not
a doctor certificate was anyway there when preparing the will, right?
Yeah. No, but so you see, 7 years before you made a will, today you are there. So the two-person, why it is required register means you go. Nowadays you give a thumb impression, you have Aadhaar card, you have a PAN card, all they connect in such a manner that there is a, your biometric
authenticity
photograph taken. So that makes you helpful in the sense to the appropriately something goes wrong.
Okay.
Pradeep, just correct me. I mean, what I have got the opinion that a document has to be registered within 4 months from the date of execution.
Maybe. Yeah.
So, after 7 years, I do not know.
No, you have to make the same documents.
You have
the same documents you type.
Yeah.
Basically, within 90 days, the same documents you type and take it to register.
Because you get 4 months to register, not 7 years.
I am taking the spirit of the documents of contents. The documents constants also will change. If supposed to be somebody
they will not entertain after 7 years. Your registrar's office, you can take the will and check with them.
So I have to make a new will basically.
Within 90 days, you have to go to the registry office and they verify and then take it.
There's a time limit.
Yeah.
Okay, thank you.
So, Pradeep, if nobody has any question, I have one more question here.
Suresh, I have a question. Can the executor be authorized in the will to decide on any issue that comes up at the time of execution?
You see, executor's job is to carry out the will as desired. Suppose the liabilities come, executor takes a decision that I have to pay this. So the executor takes the decision fairly, unless somebody files against the executor. Suppose I am the legal here, I did not like executors. Then again is to go to the litigation. But executor generally has been allowed to carry out the activities to the best interest of the all beneficial owners.
See, executor cannot take any decision on his own. He has to abide by the wishes of the testator. What is mentioned, suppose he says, this house will go to A, this shares will go to B. Now, executor can't say, okay, house you transfer to B. Like, he has got no authority.
He cannot compromise actually.
Decision of the testator. He has to just follow and execute the wishes of the testator, one who has made the will. He cannot take any.
He cannot change anything.
Or
He
any
just
cannot
executes.
change the allotment of assets to beneficiaries.
He can implement.
Yes. Yes, you just implement the will, the wishes.
29 participants.
I will make it simple. Suppose I had a house which I said can be sold after my death, and the money be get distributed between the legal heirs. So the nominees may differ in their opinion that whether the house should be sold right away or after 1 year.
You are telling
In
me.
that case, who makes the decision?
Yeah, let us tell you simple thing. The houses you are telling can be sold.
Yes.
Can be sold by whom? The legal heirs.
Yes.
So the legal heirs to take a decision. So you have to give the house to the. You are not telling that house will be sold after selling. I have a 10 lakh of liabilities. They pay and get this. So if the house is there, you have a 10 lakh liabilities are there. You have to mention that. So the executor will ensure the compliance of that. But if you are telling the house can be sold, it's a intangible wishes. House may not exist. China gives a war, house may not be there. So your house will go to the 3 people or 4 people or 1 people to whom you desire. So that is the wish. And your wish can be intangible or tangible. So wish should be tangible in case of legal form.
Okay, I'm sure there would be more questions. I'm sharing on the screen the email IDs of Mr. Saha and Mr. Pradip Mansukhani. You can write to them directly. I'm sure there could be questions which are private in nature and you would not like to kind of publicly share them. You can always write to them and they would get back to you. We will be sharing this presentation also with you. Along with that, this will also go.
Thank you so much. Thank you so much.
One last question, Pradeep.
Yeah.
Pradeep, what is the cost of registration?
Cost of registration is not more than 5,000.
And okay, thank you.
Perfect.
Perfect. It depends on which lawyer. If you ask me, I'll tell you go to Lakshmi and Sridharan, he'll charge you 2 lakhs. you can go to, that is the one of the best person. But you can tell that I'll go to Pradip Mansukhani. Pradip will not charge more than 5,000.
No, but either Bombay may, I think it's up to 30,000 rupees, maximum is 30,000 in Bombay. A document which you go to register, a flat agreement and all.
It is not the nominal charges, but it depends on the quality of lawyer, quality of property. If you have 1,000 crore property, then obviously you have to go to best lawyer.
It will cost at least 1 lakh to 1.5 lakh.
Let me tell you, I have met. You see, I'm telling you one story, as you know. So, one day I've gone to South Zone when we were working in finance department to file a case against the distributors. Distributor check is dishonored, this, that. The lawyer told me that you have to file in Chennai. Then I asked another lawyer. I said, can I do it Bombay? Deposit? Because who will go to Chennai and to attend the lawyer? Yes. So our office, Colgate, used to keep a check, account pay in the favor of Colgate Palmolive. So he deposited the check in Bombay, and the check is dishonored. So we have gone through one lawyer who is very famous now, Mahesh Jetmalani. So he has sent a letter from Bombay coast to appear. Even happened in Calcutta also. So West Bengal, we have deposited Bombay. So they settle. It depends on the circumstances of your decision. But it is not very costly. It's within some nominal, like Pradip Mansukhani will tell you, a normal fees.
Okay. Thank you so much.
Thank you, everyone. And
thank you so much.
Nice talking to you, all the friends.
thank you. Thank you, Pradeep.
Thank you, Pradeep.
Thank you, Pradeep and Pradeep. Thank
yes.
you, Devi also.
Mansukhani has done very detailed work.
And
Thank you,
PSG and Ruchi also.
Yeah, thank you so much.
Thank you very much for everyone.
Before we sign off,
Pradeep.
just a small request of all of you, if you would like CPIA, that is the CP India alumni, to bring such expert talks on other topics of general interest, please share your suggestions with Mr. Natani. All of you know his phone number and his email ID. Please write to him and we will try our best to bring them.
Thank you so much.
Thank you. Thank you.
everyone.
Thank you.
Very
Thank you all. And KV for
Thank
your
you so much.
support. Thank you so
Dr.
much.
Vaidyanathan, thank you very
Thank
much
you.
for helping us.
Munsukani, KP, Karthik, Ruchi.
Everyone.
Wow.
Good show.
Thank you.
Yeah.
Very well explained.
Yeah.
Thank you. Thank you.
Thank you.
Thank you so much and bye.